Good morning, everyone. Thank you for being here. The House Judiciary Committee will come to order. So I want to introduce myself. My name is Representative Melissa Schusterman, Committee on Family Law. But prior to that, instead of calling roll, I would like all my colleagues to introduce themselves, starting with, and let people know which county they're from. And I'll start with Chair Bonner.
Thank you, Chairperson Schusterman. My name is Tim Bonner. I represent Mercer and Butler counties, and it's the 17th House District, and forward to the hearing today. Thank you.
Thank you. And we'll start right here. The author of the bill.
Hi, I'm Christine Howard from the 167th, which is in Chester County, centering around the Malvern, Exton, Chester Springs area.
Representative Kyle Donahue from the 113th District in Lackawanna County.
Tim Briggs, representative from Montgomery County, the 149th District. Ms. Tavis is my great constituent and also the majority chair of the committee, and thank you for having this, Chair Schusterman.
Representative Joe Hohenstein from House District 177, Philadelphia County.
Good morning. My name is Dan Williams, representing the 74th District in Chester County.
Good morning. Representative Chris Pielli from House District 156, Westchester, Chester County.
And online, we have Representative Sanchez from Montgomery County and Representative Hambidge from Montgomery County. For the information of the members, this meeting will be recorded. So today, the Subcommittee on Family Law convenes to take a closer look at House Bill 2303. This bill, introduced by Representative Howard, will dramatically streamline the divorce process in the Commonwealth. I look forward to hearing from our testifiers today. Chair Bonner, you are in order for opening remarks.
Thank you, Madam Chair. I'd like to thank Chairman Briggs and Chairperson Schusterman for holding a hearing on House Bill 2303, which seeks to make significant changes in the Pennsylvania Divorce Code. This is a major piece of legislation that we are considering, and it is deserving of a very careful review, and this hearing will help assist in that review. So I thank Chairman Briggs and Chairperson Schusterman for conducting a hearing. If my recollection serves me correctly, the Pennsylvania Divorce Code was last significantly revised in 1990. I have practiced somewhat in the family law area my first few years of practice, which was several decades ago. So I have a basic understanding of the divorce code. I had not been made aware that the Pennsylvania Divorce Code was in need of significant change. So I'll be very interested in hearing from our esteemed testifiers as to the reasoning why this bill is being considered at this time. So I look forward to the process and hope to engage in a very constructive and progressive manner with this legislation. Thank you.
Thank you, Chairman Bonner. First, we will hear from the prime sponsor of House Bill 2303, Representative Howard. Representative Howard, you are in order.
Convening this hearing on this important topic, and to my colleagues on this subcommittee for being here. Divorce touches so many people, if not you personally, then a member of your family or a friend. If you or someone you know has gone through a divorce in Pennsylvania, they probably have a story to tell about the process, and it is not likely a good one. The cost, the delays, the entire system itself is seemingly designed to make everything more difficult, stressful, even demeaning, maybe even dangerous to a person trying to leave a marriage where domestic violence is present. Do we need to make a very bad situation worse? As I began to look at the provisions concerning divorce, there did not seem to be an easy fix. There are indeed many things that need to be changed, and a comprehensive reevaluation needed to be done. Because of this, and because this is such a fundamentally important topic in the lives of the Pennsylvanians we represent, we are here to discuss the problems and potential reforms to our divorce laws and gather input from the professionals who work most closely with the system. I thank them for attending and their time working on this important issue.
Thank you, Representative Howard. Now I would like to introduce our testifiers. Today we will hear from Mark Ashton, a retired partner at Fox Rothschild and the former head of the Pennsylvania Bar Family Law Unit, and Susan Perlstein, senior attorney with the Philadelphia Legal Assistant Family Law Unit. Once both testifiers complete their opening statements, we will move to questions from the members of the committee. Mr. Ashton and Ms. Perlstein, Stein. Okay, I got it. Ms. Perlstein, please begin your testimony when you are ready, and you can decide what order you would like to testify.
Good morning, and thank you for the opportunity to address House Bill 2303 before you live today. My involvement with this draft legislation comes to you through contacts with Ben Sund in Representative Howard's office, who was tasked to develop a modern and more practical approach to divorce in Pennsylvania. Mr. Sund and Representative Howard had reviewed Title 23 and started down a road toward cleaning up some fairly antiquated provisions of the 1980 Divorce Code, which has been preserved through several sets of amendments and recodifications in the past 44 years, as Representative Bonner indicated. I was asked to review and mark up and offer comments to their suggestions to changing the bill. My own involvement, as Representative Schusterman indicated, is 40 years of specialization in this field. I clerked for a family court judge in Montgomery County just after the 80 Code was effective. I practiced law in Philadelphia for 5 years, then moved to Chester County, where my practice was focused from 1987 until 2022. I remain active in the field today, writing a blog on the subject and lecturing when requested. I last appeared before you in 2016 on the amendment to reduce the length of separation for an uncontested divorce from 2 years to 1. I've taught more than 70 courses on the subject of family law and have appeared in Pennsylvania appellate courts approximately 50 times. Although Pennsylvania was, with Illinois, among the last two states to adopt a no-fault divorce code in 1980, it approached the subject at that time with lots of concerns about protecting people from divorce and retaining some very antiquated regulations, some of which dated to the 18th century. Some of them still exist today. Technically, you can ask for a jury to be impaneled to hear your divorce case. You can seek a divorce based not just upon indignities, but cruel and barbarous treatment and other such things. No one needs to answer a divorce complaint in Pennsylvania today, which means that every judicial district has its own folkways of how to move a case, referred to, I think, in Representative Howard's introductory comments. Divorces commonly take 3 years and can take upwards of a decade. I've been involved in all of those. Contrast this with states like New Jersey, where cases are subject to statewide regulations and litigants are pushed to get the conflict resolved in a year. This is conflict that is not only frightfully expensive, which does benefit those of us who are members of the bar, but it is also emotionally draining. The cost of this costs a lot of money, as I just said, and many litigants have taken that road to report it to be emotionally exhausting. Then we have anomalies that are hard to explain. Two of our smallest counties, Cameron and Potter, had 6,500 new divorce filings last year. That's remarkable because these two counties have a combined population of 21,000, one divorce for every 3 individuals, whether adult or child. That's more divorce filings than Philadelphia and Allegheny County combined. As I should add, Dauphin County too. People are filing because they want quick, cheap divorces, and those counties have set up procedures to deliver. That statistic alone suggests that the system needs to be streamlined and reformed. So what have we drafted, or what has Representative Howard drafted with my input? A lawyer that pushes a law, I should say, that pushes parties through the system so they can move forward with their lives. Amendments where you cannot ignore a divorce complaint, as you can today, and where there is early intervention by the court to make certain that assets don't disappear, and the parties realize that the judicial system is in command of the process and not the litigants. Where there are contests, and there are plenty of issues to contest in this world, the revised statute tries to flesh out the issues early in the process rather than allow litigants to be surprised to learn that an issue like alimony or counsel fees is only going to be raised 2 to 3 years after the filing took place, which did not include those counts. House Bill 2303 is a bill that allows parties to have convenience and avoid filings in Coudersport and Emporium. Instead, you file in your local county seat, and when the 90-day cooling off period is lapsed, you can, but don't have to, go to your local district justice, or, and we may have some disagreements about that, the municipal court in Philadelphia, where that person will supervise the completion of the forms for a no-fault divorce. The reason we are introducing this is because the forms are temporally set. If I sign an affidavit of consent and do not deliver it for 30 days, it becomes invalid. And that is a worthwhile thing to retain, but parties who are pro se commonly mess it up, with the result that their divorce becomes protracted for no particular reason. We are not involving the district justices in any adjudicatory function. They are merely acting as, if you will, couriers, so that people can get their divorces locally without having to drive to the county seat. And it does not involve any judicial intervention on their part. I have provided the House with what I call a 90-day précis of what the district justice would say, which is essentially understand, folks, that if you sign to have your divorces processed and the divorce is completed, you will have no economic rights inter se. Excuse me. The 1980 code allowed the merger of custody issues and support with divorce. The trend is decidedly against that since the federal government became involved in child support collection in 1985. There's also the fact that 40% of kids today are born outside of formal marriages, which means that we have a lot of custody and support litigation, which is severable and should be severed from the divorce proceeding itself. You don't want to see your divorce delayed because a custody proceeding has been appealed to a higher court. So we took out any references in the statute that would allow support and custody to be decided in the context of the divorce docket. They will be independently managed as they are increasingly done today, as is increasingly done today. We also tried to clean up a 40-year battle over the meaning of merger and incorporation of the decree. In this instance, the legislature actually clarified the subject in 1988. The court still seems to struggle with this issue of whether an agreement is merged or incorporated and how it becomes modifiable in one instance and not the other. Prenuptial agreements are far more common today than they were in 1980. Different states take different positions on whether a prenuptial needs to be signed, how many days in advance before a marriage. This is a hotly contested subject in the family law field. Pennsylvania has taken no position on this and has affirmed prenuptial agreements signed the night before the wedding. We sought to resolve this in a simple way by providing that you provide your prenuptial agreement to the Register of Wills when you apply for a marriage license. That's a 72-hour period, so that there is at least 72 hours between the date when the prenuptial is either signed or filed and the prenuptial, or I should say the actual nuptial event takes place. At least there's a chance to do some thinking about the process. You may decide for a longer period. You may decide to retain the current law. I'm just making this suggestion. Objective time deadlines and a single place where agreements are on the record can help to eliminate wedding aisle agreements or people who have either lost an agreement or profess that one was never signed. We today have marriage by people of the same sex in Pennsylvania. Meanwhile, marital misconduct, including adultery, is retained as a factor in deciding alimony. This is one of the last vestiges of fault divorce in an otherwise no-fault jurisdiction. The draft bill eliminates fault from alimony. Alimony remains a secondary remedy that is premised upon need. A person in need is no less needy because he or she has done something wrong in the marriage. On the other hand, a person who cohabitates is likely to be less needy because that person should be sharing expenses with their cohabitant. So we have substituted cohabitation as an alimony factor and eliminated fault in the draft bill. The 1980 and current provisions of the law have a lengthy section that allows one person to require a spouse to attend counseling. Today, couples in this day and age know where to find counselors, and most people who use the mandatory counseling provisions of the bill use it hostilely. If you want to divorce me, I'll make you go to counseling. So this is something that, again, I think can be safely stripped from the current code to make it simple. Rare are instances where a person is forced by court to attend counseling and then turn around and say, well, you know what, having been forced to counseling, I actually want to reconcile with you. This section was eliminated because we trust adults know how and when to secure counseling in the 21st century. There are other technical changes, which I'm happy to answer, that abolish fault defenses to divorce and address how a person should claim that property is outside the marital property divided in divorce. In other words, we're providing that if you want to assert property claims, you should do so within 90 days, not wait 2 years and then when the other party, or a year or more, and wait when the other party decides that they're processing the divorce to say, stop the proceeding, I want equitable distribution, I want alimony. I'm happy to respond to your questions related to these changes, but my theory is that I can save your time and my energy by responding to any questions you may have. Thanks for the opportunity to speak on behalf of the bill.
Thank you.
Good morning, Senator Howard and committee. Thank you so much for inviting me to be here today. My name is Susan Pearlstein. I am a family law attorney at Philadelphia Legal Assistance. PLA is a nonprofit that provides free legal assistance to low-income individuals in a wide range of civil matters. My expertise is in protection from abuse, child custody, child support, and some divorce. Divorce is actually the least of my practice, but it impacts a lot of my clients in a major way, and a lot of the pro se litigants that Philadelphia Legal Assistance tries to assist every year, as you'll see. So we try in these comments to provide the perspective of self-represented litigants and survivors of domestic violence. For more than 25 years, PLA has represented low-income survivors of intimate partner violence, child abuse, and other forms of interpersonal family violence. We annually provide assistance to thousands of pro se litigants, helping them to try to better represent themselves in family court, as resources for attorney representation are extremely, extremely slim. That's cause for another hearing on another day sometime. So most of the litigants in Philadelphia County, at least, and I'll speak mostly about Philadelphia County, but a lot of this permeates throughout the Commonwealth. In Philadelphia County, approximately 85% of the litigants in all family law matters are pro se, self-represented. They can't afford counsel, and there are very, very limited resources for free legal assistance, especially in divorce, and that is throughout the Commonwealth, because the resources, the small amount of resources that legal aid organizations do have are mostly put to serving survivors of domestic violence, child abuse, and divorce is often not the most urgent need. So it remains a large unmet need. So due to this large unmet need, the Jenkins Law Library in Philadelphia started doing a divorce clinic 2 mornings a week in Philadelphia Family Court at a help center, which we originally started as a collaborative effort for custody pleadings. The custody is open every day from noon to 3 and is extremely, extremely busy. The divorce, they only have the ability to do it 2 days a week. They can only serve 10 litigants per day. And I got some statistics from the providers. They have to turn away at least 5 to 10, maybe more people every single day. I have more details in the comments, but they often hear from litigants that they have to make several trips before they get to the help center in time to be seen that day. And then once they are seen and they start their divorce process, it requires, because of the complicated procedures and the wait periods in the divorce process, they have to return to the help center several times throughout the process of the divorce. And this is only if you have a no-fault 1-year separation with 0 equitable distribution. If there are any complications, like there's at all debt or assets that need to be divided, or one spouse that is, their whereabouts are unknown and you have to go through this tedious unfound process, the clinic can't assist you. And then you're even kind of more out of luck at that point. So let me go back for a second. We applaud the simplification of and increased access to the divorce process in the Commonwealth. An affordable means to divorce for the average Pennsylvanian as well as for the indigent is often completely out of reach. I discussed the large unmet need, and some statistics from the Divorce Help Center are at least, they helped in the last year at least 597 unique individuals, over 952 visits in 2023. They don't track the exact number of people who are turned away, but as I said, there are often people that need to return multiple times before they can be seen for the first time. And they do turn away upwards of 15 to 20 people each day. At least 121 of the individuals helped in 2023 were assisted to receive informa pauperis waivers for the filing fees. An average of 9 to 10 were assisted on each day. An average of 36 minutes is spent with each litigant per visit, but that can be quite much longer, especially if there's interpreter services needed, which we do make sure that we have available, and we use Language Line. About 62% of the visits were regarding 3301D grounds for divorce based on 1-year separation, and about 31% were mutual consent. So it's obvious the need is clear. And like I said, we really applaud, and I think most family law practitioners would agree, the divorce code needs to be amended, simplified, and the process needs to be amended. I will say that I was asked to relay to the committee that there are many practitioners, the PA Family Law Section, the Philadelphia Bar Family Law Section, obviously some of the Judiciary and Court Administration would like the opportunity to review the bill and comment on the bill as well. I don't know that a lot of people were aware of how quickly this was happening, but I do think the majority of people agree that this is a really important thing and should happen, and it would also need to include looking at the rules of civil procedure, obviously, and ensuring that the rules make sense and are modified as well to reflect any simplification, which would be very welcome. Regarding some of the specific provisions, one provision that was taken out is 3301C2, and we do applaud the elimination of fault grounds. As Mr. Ashton said, very, very few people proceed on fault grounds. By the time you can get your fault grounds approved, the 1-year period separation has already passed, and I don't know hardly any practitioners that proceed under fault grounds any longer. There really is no reason to. We are, however, concerned about the elimination of one provision that is currently in the statute as 3301C2, which states the consent of a party shall be presumed where that party has been convicted of committing a personal injury crime against the other party. And we do see survivors of family violence and crimes use this provision to proceed with their 3301C divorce. I do understand in practical terms, by the time somebody is actually convicted, again, a year has usually passed, but if there's any way to keep the simplification and skip some of the steps for a survivor of domestic violence, we would want to keep that provision in. Additionally, I think, as I said in the statement, there may be a drafting error because it says that a consent of a party to a decree shall be presumed if no answer has been filed, yet that would allow for a spouse to proceed with a mutual consent divorce with only one party having to consent. I'm not sure if it's just drafting.
I've spoken to Mr. Sund of Representative Howard's office, and I do believe that is an error. It was not our intention to be able to secure a unilateral no-fault divorce after 90 days. The one-year provision would be what I would be recommending because it is an emotional process, as anyone who has been through it understands.
Yeah, thank you. No, thank you for that clarification. And I think there's something similar with 3301D too, irretrievable breakdown. And we would just want to be sure that there are specific guarantees that each party is properly served before another party can proceed by default without receiving a notice back. Because, as we know, especially in some situations where there's been domestic violence, there is often service falsely verified. Yeah,
Right.
it's, they purposefully may use an old address or do things, other nefarious acts that we just really want to be sure that everybody has fair notice. Another important section that we would be concerned about eliminating is Section 3332, opening or vacating decrees. Over the almost 3 decades that PLA has been providing assistance to Philadelphia's low-income population in divorce matters, we have seen many, many cases in which a spouse learned of a divorce way after the entry of the divorce, whether it be in Philadelphia County or in one of the other counties that were mentioned, like Cameron County, where a lot of no-fault divorces are processed, but sometimes the other party has not received proper notice or didn't know about it. So we would urge that that provision be kept in some format so that there is a fairly simple way for someone to claim that they were not properly served or a divorce when it was entered improperly to open and vacate within the statute. Moving on to the general order of divorce proceedings, again, we really are excited about the changes that would come about and the simplification and streamlined procedure. About written agreements, when both spouses wish to be divorced, I think it's wonderful to have a way to do that in a more quick fashion and to have the parties be able to sign an agreement and have the divorce be done more quickly. However, I do have a concern about the municipal court and any other court getting involved in the divorce proceeding. I'm not sure, and again, I'm only really speaking about Philadelphia County because I don't practice in the other counties, but to have another county, another building, another court take pleadings in a divorce case and then have that pleading have to be consolidated with an already started action in the Court of Common Pleas, whether it was the municipal court or another building, and then send it to the Court of Common Pleas, DR Domestic Relations. I think it would be a nightmare, unfortunately. We have trouble with filings and pleadings in Philadelphia as it is. We don't have electronic filing. Unfortunately, sometimes things don't get docketed right away. Sometimes things get lost. I won't go into what happened during COVID, but you can imagine without electronic filing is very difficult. And I do have a lot of concerns about telling litigants to go to a whole different building, municipal court. A lot of practitioners as well as litigants have no idea where a municipal court is. And I think it would just cause a lot of confusion. I think it may be a solution in other counties if what Mr. Ashton's saying, it may make sense, say, if the county seat is 100 miles from where you could file in municipal court, of course, you might not want to have to drive 100 miles to the county seat if you're in a rural county or something like that. But I do have concerns about taking pleadings in a different building even. I think it could be a cause for concern. Regarding section 3321.1, B and C, the economic issues and hearing officers, we are very pleased to see the addition of 3321B to allow the court to quickly address the preservation of assets and the need for discovery. This is a tremendous improvement that's much needed. Oftentimes, those proceedings don't happen for quite a long time. You can file a special motion to preserve assets. A lot of people don't know that you can do that, or that you should do that, or that somebody might even be trying to dissipate assets. So addressing the need for discovery and the need to preserve assets in the very beginning of a divorce is a really good improvement. I would like to raise the possibility of amending 3321.1C to allow for only record hearings by hearing officers and the consideration of an alternate procedure for equitable distribution proceedings. A possibility may be to employ through the rules of civil procedure, a similar procedure as the Commonwealth counties employ for child support and spousal support matters. And in that procedure, parties appear for a record hearing before a hearing officer after they go to a conference if they can't make an agreement.
I'm going to stop you right there.
Yes.
Because I do want to make sure we have time for
I'm
questions.
sorry. Yep.
But I thank you both speakers. Encourage you. We're going to submit the remarks so the entire committee can read those remarks. And both of your expertise and being able to kind of drill down to this large omnibus bill is just very much appreciated. And I would like to start with a question of my own before I ask my co-chair and other people on the committee. This is a big bill, but a necessary bill. Which part of the bill do you think would make the greatest impact on the process of going through the divorce that will streamline it? Now, I might know your answer because you kind of were really impressed with locking down assets and that aspect of the bill, but I'll go to you first, Ms.
I think that is one of the large improvements. I think obviously taking out the fault grounds makes sense. And I think looking at some of the waiting periods and making mutual consent easier and taking out some of the waiting periods. So I think Mr. Ashton spoke to this too, but there are some of the procedures, and every county has a little bit of different procedures, so it's difficult to know exactly. But for some of the procedures, you file one thing, you wait 90 days, then you wait to see if you get the response, and then if you don't get the response, you file the same thing again, basically. It just is an onerous process, and I think cutting some of that out would be wonderful.
Mr. Ashton?
Substantively, I couldn't agree more. As all of it, I see that I'm amongst many other lawyers in the typical Pennsylvania action of any civil action of any kind, you have to answer a complaint within 20 days. When I first saw the first draft of this bill, it sort of implied the same thing, and I said, well, that's probably not, that's too fast for people that otherwise might be surprised to learn that their spouse wants a divorce. On the other hand, especially in a post-COVID period, we're moving into an age of case management instead of raw trials. And what you want to have, echoing what Ms. Pearlstein said, what you want to have is the message of a judge, I'm in control of this case, and that I am going to make sure that justice is done. There is no such procedure like that in Pennsylvania today. And I will enter temporary orders to get where we need to go, but I want you people, meaning you divorce litigants, to basically pay attention to your matter, because it's in the judiciary's interest to get this case resolved, and frankly, you will find at the end of the day, it is in your interest to have it resolved, both financially and emotionally. And collaterally, it will be in your children's interest if you have minor children.
Great, thank you. And Chairman Bonner, do you have a question?
Thank you, Madam Chair. I certainly have more than one question, but I'll just make a few quick comments and then ask my questions. So the issues that concern me the most that you have properly raised in your presentation today, I do have concerns involving the minor courts. Many of these people do not have much legal training, and I still think they play at least an oversight role in the divorce process if we place jurisdiction within them. Not to be critical of our minor courts, but some of the people who hold these seats, particularly in the rural counties, have run car dealerships. So giving the minor courts jurisdiction over such significant matters as the breakup of a marriage, I do have a concern with. Secondly, I have a concern with the prenuptial language. Prenuptials, as we all know, have been a significant area of litigation and a very prominent area of court review. And one of the things that everyone seeks with prenuptial agreements is privacy. And yet filing this document in the courts without any confidentiality to it, I think will be a major concern for those who are involved in the divorce process. So confidentiality will be lost by filing it with the courts. My third and final comment is I think there'll be a major debate on the alimony issue for those who are involved in cohabitation outside of the marriage. Losing a spouse and losing it to a certain other individual and now having to pay alimony into that particular household, I think will be just a major area of controversy. But my questions are, and Mr. Ashton, you raised the first issue, venue shopping. We've seen a lot of venue shopping in divorce proceedings in the past, a lot of advertising. Do you think this bill will help solve venue shopping? Or are we going to see certain counties and certain lawyers advertising these $100 divorces in certain counties? Does this bill address the venue shopping issue whatsoever?
I can't assure you that it would. But what I will say is, and I want to address your questions specifically to this topic about the district justice. What I see to be the merit of the district justice system is not the district justice. In fact, we are imposing upon them. But what I see is that if you live, if I recall Mercer County, if you live in Mercer and you're in Crawford County and you've been sued for divorce, you can get something resolved without having to drive to Mercer. And curiously, I've thought about Ms. Pearlstein. We spoke, and I thought about her comments. The same thing could be accomplished in the prothonotary office by setting aside a time when parties can come in and sign their documents contemporaneously, hand over a document if they have a written one. I'm not married to the concept, poor choice of words on my part, I'm not married to the concept of it has to be the district justice. I'm just saying I want to make it convenient because the average litigant who has a countersport divorce doesn't know where countersport is and has getting no real insight as to why it is that somewhere either a mile or halfway across the state is intervening in their marriage.
I'll just to kind of pinpoint you, because we don't get to talk with experts such as yourself very often, but again, do you think this bill in any way will help lessen the venue shopping by divorce lawyers and clients, so that we don't see Perry County, just as an example, handling thousands of divorces that really don't have any relationship to them?
Well, what I'd say is, obviously, the Supreme Court could resolve this, and I suppose the legislature can resolve this by tightening the venue rules. I believe, anyway, and now I'm challenging my own memory, in the early days, you could not waive venue. The Supreme Court amended the rules to say that venue could be waived, and in so doing, they kind of created the forum shopping you're seeing right now. And actually, in the work that I've done with the Joint State Government Commission, it was reported to me that basically these counties they're not equipped to handle litigated divorces. They are merely providing a service. And I don't mean to deprive them of a service, but it doesn't make sense to me that we have 6,500 divorces a year being filed in counties that people don't even know exist.
But I don't see this bill stopping that. So do we need to address it more aggressively?
Well, but what I'm suggesting to you, Representative Bonner, and please disagree with me by all means, but if I know that my district justice, who is 8 miles down the street and who I last saw because I had to pay my parking ticket late, can process this, why would I think about going to a county I never heard of?
Thank you, Chair Bonner. I have one that actually kind of is a follow-up of what you asked. So we're saying about 40% of children are born outside of marriage, and a lot of people are cohabitating. And I think cohabitating goes two ways. I was recently approached by someone who cohabitated with her partner of her dreams. They both didn't want to marry. They had a child together, and then they separated or divorced. That's 10 years of living together and presenting to the world as a couple. So I think when we move forward with this bill, we really need to address those families as well. They have children, they've lived together, they've both paid for things in the household, and it looks different than a person who divorces and then lives together, and then you're paying alimony into that. So I'm bringing that back to the alimony question here in Pennsylvania. I know other states are kind of wrestling with this.
So I'll just say that, first of all, to Representative Bonner's question about the venue thing, I just wanted to go back to that real quick. The rules of civil procedure state that you can waive the venue, proper venue, right? And obviously the reason for people doing it outside of their own county is because the fees are so low. I think one way to eliminate some of the venue shopping and to simplify the procedure is to have uniform forms and uniform procedure across the Commonwealth. And I would love to see that across the board in all of the domestic relations areas. So you could go online and find one complaint, which you can, but it's like a little different for each county, right? So you could find a form. This would assist so many of the self-represented litigants and the people who can't afford legal aid or legal representation and who don't find legal aid for whatever reason. It would assist in all our volunteers and law students and interns that assist people with filing pleadings if there were uniform procedures throughout the state, throughout the Commonwealth, for custody in particular, as well as divorce, because there's not always, and also electronic filing, right? So if you had electronic filing, you wouldn't need to necessarily go in person. You could get it notarized, you could have an attorney, and then you you file it. I understand wanting to have, for something so important, wanting to have people appear in person with an ID, but it could also be notarized, and then filed electronically. So if we had electronic filing across the Commonwealth, which someday would be great. I think Philadelphia is one of the only counties that doesn't have electronic filing for family court. I'm not 100% sure on that. Anyway, so that would be regarding the venue shopping. The next question you had was about the cohabitation.
Looking at cohabitation as
Yeah.
a family, people have children, 40% of children.
Yeah, I don't think that we would need to address it in this bill, because
Good.
this bill particularly is focused on people who choose to enter a marriage and then wish to dissolve that marriage. Some people never choose to to be married, and that's fine. And I think there are ways for people to deal with their custody of their children and support of children. The property issues are a little bit different, but I think that's the choice that people make in not deciding to enter a marriage.
No, I thank you for pointing that out. But
If
as
that
we-
was what you were asking, I'm
Yeah,
sorry,
it was. We basically have 40% of children are born
Outside of wedlock.
outside of a marriage. So, they're coming to a court near you.
Not necessarily.
if I
I mean,
can-
some people who have never been married, never.
I think
never,
it's sticky. It's equally sticky for those people. I'm hearing from constituents, it's equally sticky. Not to be addressed possibly in this subcommittee, but I do want to make sure we wrap up on time and throw back to the maker of the bill, Rep. Howard.
Before I make my closing sentence, I just wanted to say what you're talking about, Melissa. Pennsylvania used to have something called common law marriage, and it was very outdated and went away. We got rid of it.
And no, I don't think anybody wants it back.
Right, but we kind of the goal of like people held themselves out as married, and now we have a lot of people who aren't married, and they are acting as though married, but not having the protections of marriage such as they are.
Right.
Could I just quickly
go-
answer two
go ahead.
points that Representative Bonner raised? Apropos the prenuptial agreement, a very good point, and the benefit I had today was I drove out with my longtime friend, Leslie Tabus, who's also practiced in this area as long as I have. And she said, don't file the agreement, but file a document indicating the agreement exists and that the confidentiality wishes to be preserved. Apropos the alimony, the bigger concern that I have is, if I leave my wife and move in with another woman, I am ineligible for alimony. If I leave my wife and move in with another man, I still have rights.
And that provision does cause a lot of confusion and fact-finding and, kind of, well, you did this, but you did this. Alimony is really, it's not so easy to get any longer, right? And it really should be, I agree, it should be based on each party's ability to move forward for some period of time, right? Until you can maintain your own self-sufficiency as the marriage is dissolved. And I think it does make sense to take the gender-based language out of it, right? You just want to look at each person's situation. Are you on your own? Do you have help? Have you moved in with your parents who are, millionaires and you don't need the help? It just depends.
Well, due to closing out on this hour, I'm going to get right to my closing remarks. I'm going to thank both of our speakers, and I am going to throw to... Oh, you have a question? Oh,
It's not a question.
Chairman.
I had a meeting with the leader, but I want to thank you for having this, and I want to thank the representative for introducing it back in May, which was when we first announced that this hearing was going to take place. So when you mentioned that folks didn't know, I understand practitioners don't pay attention to our meetings every day, but there are people who do, and I think those people need to be a little bit more responsible for kind of starting a conversation we didn't know about it. So we are open to listening from everyone on this. I've suggested everyone submit comments in writing, communicate with the prime sponsor regarding concerns and improvements. But this is why we have a hearing to get input and to learn more about it. So we gave months' notice. Usually we don't. We flagged it that this was going to be something we talked about, and I want to thank the representative for scheduling this. We could have done it in June, but she thought it was best to wait and try to give folks an opportunity to digest the bill. So it is a little bit frustrating, but I do thank both of you for coming today and helping us understand this a little bit more. Chair, back to you.
Thank you. I would like to kind of do this out of order. I'm going to throw to the maker of the bill for her closing remarks.
Just a couple sentences. I want to thank our testifiers for their valuable and insightful perspectives. Hopefully, we will all have much to think about as we move forward on reforming our divorce laws. Thank you again.
Thank you. And Chair Bonner, any closing remarks?
Again, I just want to thank Chairman Briggs and Chair Lady Schusterman for having this hearing and for inviting two very esteemed colleagues of the bar to offer their input. I think your testimony today has been very helpful, and I appreciate your open-mindedness towards some of the suggestions, and look forward to working with you in the future as well. So again, thank you.
Thank you.
Thank you. And I would like to thank both our testifiers, as well as everyone who's here and people who are listening at home or will be watching this later. And a special thanks to our Chairman Briggs and the entire judiciary staff. I am not a lawyer, but I did go through a 10-year divorce. So I am passionate about this bill, as well as the bill we were able to pass with the PA Bar, the arbitration bill that became law. So we are going to continue listening, learning, tweaking, and getting this across the finish line. I thank everyone. This meeting is adjourned.